Chikati Ward, Chengara Town Council, Buxton District, indicating that Honorable Mugindo is a resident of this area of Kiiza, and a photocopy of Honorable Mugindo's national identity card. Honorable Mugindo presented his national identity card.
So we are Jikola Bunji, Chintu Gwenchaga, what are the Kevin to Winch? No one watching a Chintu.
Honorable Francis, a 41-year-old male adult, member of parliament for Mukooti district, resident of Tete, Kiiza Cell, Masoli Ward, Kasanga Town Council. Honorable Mukooti is a close friend of the first applicant. On file is an international letter from Tete, Masoli, Kiiza Cell, Masoli Ward, Kasanga Town Council, Buxton district, indicating Honorable Mukooti is a resident in this area. And a photocopy of Honorable Mukooti's national identity card is on record. Honorable Mukooti presented the original of his national identity card for court inspection for Honorable Kamara Nicholas Kadias, a 50-year-old male adult, the MP for Kabale municipality, a resident of Buye, Chigowa LC1 Mukooti 2 Parish, Nakawa Division. Honorable Kamara is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson Buye, Chigowa 1 LC1 Mukooti 2 Parish, Nakawa Division, Kampala, indicating that Honorable Kamara is a resident of this area, and the photocopy of Honorable Kamara's national identity card is also on record. Honorable Kamara presented the original of his national identity card for court inspection. The second applicant presented 3 sureties as follows: Najita Halima, retired, a 58-year female resident of Kisugu, Makindi Wakiso district. She is the wife of the second applicant. She is a businesswoman engaging in business with her husband. She presented an introduction letter from the LC1 chairperson of Kisugula village cell, Motunde Ward, Gomorola Sabagabo, Makindi Wakiso district, indicating that she is a resident of this area. Mrs. Utare presented the original national identity card for inspection. 3. So Kamsa. The 48-year-old male resident of Kanave village, Ndege Parish, Sabagabo Makindi, Wakiso district. He is an advocate practicing with Soakambo and company advocates. Mr. Soakambo is the brother of the second applicant. He presented an introduction letter from the Kanava cell, Ndege Ward, Ndege Division, Makindi Sabagabo municipality, Wakiso district, indicating that he is a resident of this area. Mr. Soakambo presented the original of his national identity card for court inspection. 3. Nafukazura, a 27-year-old female, resident of Lukuli-Konge Parish, Tiara Zone, Kampala district. She is a journalist by profession. Ms. Nafuka is the daughter of the second applicant. She presented an introduction letter from the LC1 chairperson of Tiara Zone, LC1 Lukuli Konge Parish, Makindi Division, Kampala district, indicating that she is a resident of this area. Ms. Nafuka presented the original national identity card for court inspection. By presenting the originals of their national identity card, the letters of introduction from the chairperson of LC1, where they ordinarily reside, the sureties satisfy the conditions set out in Guideline 15 of the bail guidelines. The aforementioned guidelines do not provide guidance on the format the introduction letter should take and what it must take. Neither do they make reference to permanency of residence in terms of owning property as alluded to by the respondent, like his reference to land titles and sale agreements. I am not persuaded by the respondent's argument that the first applicant's sureties are not suitable as sureties. Only the fact that they are friends are not blood relatives. younger than the applicants and therefore are not able to execute their duties as sureties. The first applicant sureties are his close friends and leaders in a political party of which the first applicant is a member. By virtue of their position as close friends of the first applicant and leaders in a common political party, they are able to exert influence over the applicant to ensure that he abides by his bail terms in the event that he is released on bail. The fact that they are younger than the first applicant, notwithstanding, reference to age in the bail guideline as a parameter for determining suitability of a surety does not indicate that a surety must be necessarily older than the applicant. It is enough that the surety is a responsible adult with a connection to the applicant, capable of exerting influence on the applicant complying with his bail terms. In the premises, I found the first applicant's sureties substantial sureties capable of exercising authority over the first applicant to ensure that he abides by the conditions of bail in the event he is granted bail. The second applicant's relationship to his sureties as husband, father, and brother respectively. The fact of their being younger than the applicant notwithstanding, in my view, arguments their ability to compel him to comply with his bail conditions in the event that he is granted bail. It is enough that the sureties provide copies of their national identity cards and introduction letters from local council chairpersons of the areas where the sureties are ordinarily resident, are set out in paragraph 15 of the paragraph 15 to A and B of the bail position guidelines for courts of judicature, class directions 2022. The aforementioned guidelines do not provide guidance on the format of the introduction letter that should take and what it must take. Neither do they make reference to permanency of residence in terms of own property as a residence contract. This refers to land titles and settlements. Accordingly, that declared relationship between the sureties as close friends presented by the first applicants admits their suitability as sureties. The declared relationship between the second applicant and his second and third sureties and the relationship of the first surety as the wife or the first applicant admits their suitability as sureties. Also, as one of the factors considered in determining the suitability of sureties, the bail guidelines mention age. It does not, in my view, indicate that the surety must always be older than the applicant. It is enough that the sureties are adults in positions of responsibility or so connected to the applicant that they are able to exert pressure on the applicant to comply with their bail conditions if granted bail. To say that a surety must always be older than the applicant is to set a dangerous precedent. Where senior citizens of very advanced age may never be able to find the sureties who are older than them. I now find that the first and second applicants have satisfied the requirements to present substantial sureties. Exceptional circumstances. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda was retired Colonel Dr. Kiiza Besigye Supra. That proof of exceptional circumstances for bail is not mandatory. In this application for bail, however, the first and second applicants lie on the adverse aid as their exceptional circumstances. Section 16, subsection 3, part C of the TIA provides that the exceptional circumstances include the infancy or advanced age. There is no doubt that the applicants are 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, subsection 3, part C of the TIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Uganda Road Court. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Uganda Road. By interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail, and has not been proved that before he had deliberately for no justifiable reason. The first applicant was released on bail in respect of the nature of the offense and conspiracy of the commencement of value. Therefore, the applicant has a case of Makoha summary but the second charge in respect of where the applicant is not being charged by no contract section.
What's the double? When you say
Terrorism Act. It was submitted for the respondent that the applicants in this case of Makoha Samuel are charged with terrorism, which affects livelihood.
amafuta egansazeko nasuze ndi mwavu kamotoka kantu kako sente guloze nadde upkeep gye
which affects the sentence of death upon conviction.
gakyantuddemu.
I am persuaded that on the scale of gravity, the charges against the applicants in this case affect the ultimate penalty and therefore are braver than the charges against the applicants in the case of Makoha Samuel and 35 other versus Uganda. While the charges in both cases are grave, the charges in the present case, in the present application, are more serious. Therefore, the applicants stated that the International Crimes Division of the High Court held in granting the applicants bail in the Makoha case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, basing on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In the Uganda DPP versus Colonel retired Dr. Kiiza Besigye, Constitutional Reference number 20 or 2005, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant submitted that no evidence has been adduced in support of the averment that the offense impacts on the national security of Uganda. It was added that the investigators have placed nothing before this court to to suggest that there is evidence of any nature at all of it suggests that what they aver in their response to this point. As for the response submit that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation and witnesses. It was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. As for the applicant cited Panju versus Ara, 1973 African Law Reports at page 282, where it was held that allegations of interference with the witnesses must be substantiated, that such substantiation is not difficult to show. In reply, counsel for the respondent submitted that the first applicant is a prominent and influential person, and the second applicant is his personal assistant. That in releasing them on bail, will accord them the opportunity to interfere with witnesses and investigations which are still ongoing. As for the respondent, on the case of Okello Augustine versus Uganda, application number 6 of 2012, where the court emphasized that once the likelihood of abscondment and interference with investigations have been established, the court should be hesitant to grant bail. In this case, the respondent states that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to say in detail how the applicants are likely to interfere with the investigations which are ongoing, the particular circumstances of the case against the applicants must be borne in mind. The offenses are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere with the likelihood to interfere with the investigations which are still ongoing. Decision. The main consideration for release of an accused person on bail are the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty except in execution of the sentence or order of a court, whether established for Uganda or another country, or of an international court or tribunal in respect of a criminal offense of which that person has been convicted, or of an order of court punishing the person for contempt of court. Article 28, 3, Constitutional, refers number 20 of 2005. Among the considerations for exercise of this discretion is the gravity of the offense. Courts will more readily grant bail or for less serious offenses than the serious offenses. The offenses with which the applicants are charged are among the gravest, if not the gravest, offenses of our statute books. In all cases where applicants are charged with capital offenses, the court must always have in its mind the overarching consideration of the gravity of the accusation against the applicants and the sentence that it attracts. As stated in the case of Okello Augustine versus Uganda, Supra, while acknowledging the release of one accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The circumstances of the present case are that it is alleged that the offences were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offences are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in respect of offences alleged to be committed only in Uganda. It was argued for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigations will conclude, to facilitate the committing of the applicants for trial to the High Court. As for the applicants, says that there will be therefore this substantial delay in commencing the trial. Article 23(6)(c) of the Constitution provides that where a person is arrested in respect of a criminal offence, only by the High Court, such a person shall be released on bail on such conditions as the court considers reasonable. If the person has been remanded in custody for 180 days before the case is committed to the High Court, I am of the opinion that this provision takes into account circumstances like the circumstances of this case, where a person, where one reason or another, investigation cannot be concluded speedily, and provides a cap on the time on remand, without committal beyond which time the accused person shall be mandatorily released on bail. To safeguard against the right of the accused person to liberty being indefinitely curtailed. Where the applicants for bail have not yet clocked mandatory bail, bail is a matter of court's discretion, as provided under Article 23(6)(a). In this case, the applicants have, among other factors, proved they have a fixed place of abode, have substantial sureties, are of advanced stage, and are of first-time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, when granted bail, the applicants did not abide by the bail conditions. While the first applicant has charges pending against him at Uganda Road Court, for which he has cited in John Muhango's Kashaka versus Uganda, Supreme Court Missions Application number 18 of 2023, all factors to a bail applicant's credit, including being a first offender, being advanced age, having a fixed place of abode, recede to the background when weighed against the seriousness of the offense. In Young versus Uganda, Court of Appeal of Uganda, Missions Application number 99 of 2013, it was stated that the granting of bail by court one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail and reaches a decision based on the rules of reason, justice, and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial sureties, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. 1. The charges against the applicants are among the gravest, if not the gravest, on our statute books. The offences are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offenses alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigations. Signed, Rosette Comfort Kania, Judge, 11th April 2025.
We shall overcome. We shall overcome. We shall overcome someday. I do believe we shall overcome someday. I do believe we will rise.
How are you, bro? Yeah, aku continue ako. Continue. Talking ko. The court is done and the bail is being denied by the judge of this high court.
Yes, musango gwa Dr. Kiiza Besigye beire badde olwaleero kubadde ku rulinga out oba yes court bail ruling ebadde ya leero gavumenti evuddeyo n'egaana beire yasabibwa Dr. Kiiza Besigye okweyimirirwa wadde nga abamweyimirira babadde substantial nga basukka babiri nga webali ne kooti ebikutuli mu gundi eyo. So baganda bamwe bali kugoberera Map Media TV, waliwo video gyentaddeyo, genda olabe video eyo gyentaddeyo kati ekwatagana ku chairman Nyanzi, mukoddomi wange chairman Nyanzi ne Churchill mutabani we wa grade president gwenno ayina ebintu byowulira ng'oyagala okumanya ekituufu genda owulirize ojajinge. Oyinza ogitwala nga ntuufu, oyinza ogitwala nga nfu, oyinza ogiteeka wakati awo, kyonna kyonna oba otutte ejja kuba ndowoozayo video emaze okutuulayo. Genda ku YouTube bwenvaako wano, gendayo bugenzi ogirabe video eyo. Naye nga mbaagala nnyo, mwebale nnyo okwagala Map Media TV. Facebook tugenda kuba tukomawo nga tukola kinnawadda naye nga post kweziri. YouTube tubadde tuyimiriza mu kokatini nnyo mukaawo, tubadde tulina bye tutegeka ne naye genda kuddamu ekomewo ng'ebaweereza buli lunaku. Akuume atakuumira mpeera, Map Kabwejumbira Charles Mpanga, LC5 kansala wa Kiso Town Council addako 226. Banna wa Kiso Town Council mbatumiddeko mwenna ne banna wa Kiso